So, hello everyone. I'm really pleased to welcome all of you here. Today we have a very interesting topic for discussion during our Ukrainian Bar Association webinar, and we will deal with the bankruptcy and arbitration issues. I think that bankruptcy is a quite concerned issue for many arbitration practitioners, and not only. And of course, it will be very nice to hear the view of bankruptcy problems and correlation with arbitration from different jurisdictions and perspectives. And today we have an excellent and very bright speakers panel. We have with us representatives from 4 jurisdictions. And I think I will make a brief introduction of each of you, and then we will start with our presentation. So our first speaker for today will be Anastasia Dulska, associate at Bar and Car, and she will speak concerning the Switzerland and the position of Swiss jurisdiction in bankruptcy and arbitration. We have our next speaker, Yana Chekavska, solicitor and chief operating officer at the London office of Candy. And Yana will deal and will tell us about very interesting case that she is currently engaged involving the company in insolvency proceedings in England, and will give very practical tips how to handle arbitration proceedings with the company that is ongoing insolvency. Our next speaker will be Agis Georgiadis, partner at Christos Georgiadis and Associates from Cyprus. And Agis will give us the overview of Cyprus jurisdiction and correlation of international and domestic arbitration with the companies that are undergoing bankruptcy proceedings. And our fourth speaker will be Viktor Pasechnik, associate at AGA Partners, Ukraine member of the board of UBA on Alternative Dispute Resolution Committee. And Viktor will cover Ukrainian jurisdiction and the problem of our domestic jurisdiction in relation to bankruptcy and arbitration. So I invite all of you to be active during our seminar. We have our chat box, and if you have any questions to the speakers, please feel free to write down your questions to our chat box, and we will discuss with each speaker. So, and now I give the floor to our first speaker, Anastasia Dulska, associate at Bar and Car, Switzerland, and she will deal with the perspective of Swiss jurisdiction. Please, Anastasia, the floor is yours.
Thank you very much, Irina. Greetings, everyone. Greetings from New York. I'm now here. I've moved here just a few days ago, was in Zurich right before, and it's a pleasure to be here and speak still about Switzerland. So today we are diving into a complex intersection, bankruptcy and arbitration in Switzerland, and I plan to focus on 3 key questions. The first one is, can you start arbitration once a company is in bankruptcy? The second question is, what happens to ongoing arbitrations if bankruptcy hits midstream? And the third question is, can you still enforce your arbitral award if the debtor is insolvent? And in the end, we will look quickly how Switzerland compares to other jurisdictions which we will discuss today, namely Ukraine, Cyprus, and England. So we here in Switzerland have 3 main acts which come into place when we speak about insolvency or bankruptcy and arbitration. So interestingly that neither the Swiss Debt Enforcement and Bankruptcy Act, or DEB Act, which governs insolvency proceedings open in Switzerland, nor Chapter 12 of the Swiss Federal Private International Law Act, or so-called PILA Act. Many of us know about this act. It's a guiding instrument for arbitration in Switzerland. And seated in Switzerland, international arbitrations. Neither Part 3 of the Swiss Federal Code of Civil Procedure, CCP, which governs domestic arbitration, contain certain and specific provisions on the effect of the opening of insolvency proceedings on arbitration. So I want to initially pause here because in Switzerland we have two different types of arbitration. First is domestic, which is governed by Swiss Federal Code of Civil Procedure, and the second is international, which involves parties, foreign parties, and it's applicable for arbitrations seated in Switzerland and for enforcement of arbitral awards in Switzerland. So here, Switzerland is pretty important as a jurisdiction for enforcement of awards with insolvency issues. Due to one very important case, bombshell case, which is Vivendi versus Electrim. And many people still talk about this case, although it was rendered in 2009. And why is that? Because this case was pretty guiding for the issue of arbitrability of awards of cases which involve insolvency issues. So in Vivendi versus Electrim, it was a case of French media giant Vivendi against Polish telecom company Electrim. It was ICC arbitration seated in Zurich. And eventually, after the arbitral tribunal declined jurisdiction, because Electrim, the respondent company, was in the insolvency proceedings back in Poland, in its home jurisdiction, Swiss Supreme Court confirms this award. And at that time, it was pretty big thing, because Switzerland is perceived as one of the most arbitration-friendly jurisdictions, particularly for investor-state disputes. And this outcome was surprising, because before that, no one perceived that insolvency should kill arbitration. But court here, when it had opportunity to explain its reasoning, it became very clear that how court got there. It's a very specific case. It's not widely applicable to other cases. And court had 3 steps analysis. First was capacity check. Under PILA, a company's legal capacity is decided under its place of incorporation, so lex incorporations. And here it would be Polish law, which would decide if company in bankruptcy can still be party to arbitration. And step 2 of the analysis of the court was Polish sledgehammer. Under Article 142 of Polish Bankruptcy and Reorganization Act, it declared every arbitration clause void from the day bankruptcy is opened and orders pending arbitration discontinued. And step 3, it was basically a domino effect, because Polish law erased the clause, Electrim lost subjective arbitrability and tribunal right to decline jurisdiction. It was a lot of aftershock, because it was the first time that the Swiss law let foreign insolvency rules torpedo an arbitration seated in Switzerland. And the critics were very concerned if Switzerland turned to arbitration unfriendly tendencies. But in another case, in Redcon, it was Redcon in 2012, when Swiss courts said that Vivendi was strictly guided by Polish domestic rules, which was a correct analysis. And if domestic laws of incorporation of the company, which is a party to arbitration, does not kill arbitration as such and allows parties in bankruptcy still be party to arbitration, Swiss law would not disallow arbitration, would not say that proceedings should be suspended. And that's what happened in 2012. In that case, it was Portuguese bankruptcy law which was deciding, and this Portuguese bankruptcy law was not in a position to kill capacity. And Vivendi became clearly one of cautionary tale and not a standing rule. So now, with that pretext of how it all started in Switzerland and why it became a huge thing, I want to tackle specific issues. So does insolvency strip a party of capacity to arbitrate? And the answer is no, unless the lex incorporations expressly wipes out the entity's legal personality, as happened with Electrim, but normally it doesn't happen. It doesn't happen. There could be certain issues, specifics, that the proceedings might be stayed for a certain time, and maybe insolvency administrators would have to be involved, but it doesn't outright kill arbitration. And it's not an analysis of the Swiss doctrine and also jurisprudence. So just to recap, Swiss courts look first at whether the debtor still exists as a legal person under its home company law. If it does, it remains capable of being party to arbitration, of seat-seated arbitration, even if a foreign insolvency statute purports to bar arbitration. So second issue, can foreign insolvency statute annul an arbitration clause? Again, generally not, because the validity of the clause is tested under PILA, Article 172, Part 2. So law chosen by the parties, law of the main contract, and Swiss law. And because Swiss law itself does not let insolvency void an arbitration clause, a foreign rule nullifying the clause is irrelevant unless it qualifies as Swiss international public policy, and it's rarely a case. Third issue of the analysis would be subject matter limits created by insolvency law. So Swiss law imposes few non-arbitrable niches. So we are speaking of Swiss international public policy I just mentioned. There are just a few. Ordinary contract or tort claims of financial interest remain arbitrable under Article 177 PILA, with only two carve-outs confirmed in 2021. First one is collocation disputes, challenge to the schedule of claims, so basically schedule of creditors, and second, which is still debated, at some avoidance actions, so-called actio Paulina. It's still decided because Swiss law on this issue is quite divergent, but the main rule is those niches, non-arbitrable niches, are very few. Another issue would be effect of opening bankruptcy on pending arbitration. So there is no automatic stay for international arbitrations. Tribunals usually suspend until the administrator decides whether to take over. So there could be a suspension. But if the tribunal presses ahead without the administrator, any post-bankruptcy award might not bind the estate. So it's a practical issue. It's not the tribunal has to suspend proceedings necessarily, but the practical thing to do would be to suspend proceedings for 30 to 60 days, so administrator would be able to weigh in on the proceedings. And if bankruptcy proceedings begin after arbitration has already commenced, immediate procedural consequences arise, as I just said. So there was one Swiss decision on this issue of the Swiss Federal Supreme Court, which outlined that arbitration proceedings are commonly suspended pending involvement by the bankruptcy administrator, but commonly doesn't mean mandatory. So one more issue would be awards rendered before bankruptcy. So awards rendered before bankruptcy proceedings remain valid proof of debt. Must be filed in the insolvency schedule. So basically, it's pretty technical issue because enforcement of an awards against a party in debt, if this party is situated in Switzerland, becomes a pretty technical thing. This award becomes directly enforceable, but it should be still placed in the schedule of creditors. So in Switzerland, insolvency alone does not automatically bar recognition and enforcement of arbitral awards, because this is guided by New York Convention, which is directly applicable in Switzerland, recognized in Switzerland, and also was reproduced as part of the PILA. And bankruptcy proceedings do not render awards unenforceable, so the outcome is pretty straightforward. And this is also confirmed recently in IBA report. IBA conducted massive toolkit on insolvency and arbitration back in March 2021, and Switzerland made 2 submissions in 21 and again in 2024, and this was confirmed in that submission. And one more issue which I wanted to discuss is whether arbitration can arbitration begin after bankruptcy is declared? And again, the answer is yes, it is possible. If the administrator, who now alone holds the status, consents. So here, administrator would be in a decisive seat. And Swiss law contains no statutory bar to commence an arbitration against or by a bankrupt party. So bankrupt party, insolvent party, could act both as the claimant and as the respondent. So this is a brief evolution of the case law on the issue of arbitrability. and very briefly on the issue of enforcement. So just to recap, in 2009, it was this Vivendi case, which was somewhat revised, clarified in 2012, when the court said that it's an issue of domestic law of the party, insolvent party, and if domestic law does not kill capacity, then the issue is arbitrable. Two separate issues were clarified in 2021 that awards issued after bankruptcy without administrator participation have no effect on the estate, with two carve-outs that collocation actions are not arbitrable and arbitral tribunals must step aside for insolvency courts in those specific issues, because it's a matter of public policy in Switzerland. Arbitral tribunal could not basically say, no, our award should be placed higher than other creditors. I think it's also pretty clear here. And three rulings cemented this two-step test: capacity determined by the debtor's home company law, and arbitration clause dispute type assessed under Swiss lex arbitri, so under PILA. And insolvency law influence the clause only if it rises to Swiss public policy level. So to be practical, because I know that many Ukrainian parties want to include and regularly include Switzerland as a seat for arbitration, they resort to ICC rules or Swiss rules, Swiss Arbitration Center rules. And it would be interesting, I guess, for in-house counsel, if you have those counsels, to hear those practical steps. So there would be 4 steps. First is to check the less incorporations. If the debtor's legal personality survives, Swiss tribunal will accept jurisdiction. The second would be secure administrator consent early to avoid later enforcement issues and nullities. The third would be use arbitration for value disputes, but channel collocation of poorly insolvency-driven remedies through the bankruptcy court. And finally, draft clauses with Swiss seat, because Swiss law is pro-arbitration stance and shields agreement from most foreign insolvency attacks. So Switzerland would still be a very attractive place for arbitration. I myself, back at my in-house counsel times, regularly included the Swiss seat as a place for arbitration, especially for various commodity disputes. It makes a lot of sense here, but also for various other disputes. I would not, in the interest of time, go into domestic arbitration because it's regulated differently. Different law is applicable. DEP Act, which I mentioned in the beginning, Swiss Civil Code also would be applicable. And there, just very briefly show you the differences, that yes, domestic arbitration would be temporarily blocked from the start in domestic cases, which is not automatically international, that proceedings would be frozen, and domestic arbitration would be frozen, which is not the case again in international proceedings. And insolvency can be ground to refuse recognition. It's not applicable for this case. And if there any claim the tribunal cannot hear, the tribunal must, the domestic tribunals must bow to insolvency courts for collocation challenges and for certain estate-specific actions. These are main differences. And making a conclusion, Switzerland is, as I said, very arbitration friendly, and I think we will hear from our colleagues it's certain differences with other jurisdictions which we will hear about, particularly Ukraine, Cyprus, and England. And I would not steal a thunder from other practitioners, but I'm happy to hear your questions. And my apologies for some background noise.
Thank you, Anastasia, for this interesting presentation. So I one more time want to explain to our audience that if you have any questions, so please write down to our chat box. And Anastasia, unfortunately, will need to leave after her session. So please don't miss this opportunity to ask the questions. And while our audience is still thinking whether to put the questions, I have a few questions from my side in order just to clarify the position and to receive some practical recommendation or insight. We all know that Switzerland is an arbitration-friendly jurisdiction. So, and considering the Vivendi case, so does Swiss insolvency law still deserves its arbitration-friendly badge, or it's might be treated as biggest misconception?
Yes, it's indeed the biggest misconception. This case was attracted quite a lot of attention, but it's a very specific case. But the practical thing to do before initiating arbitration seated in Switzerland is to carefully check the lex incorporation, so basically the law of the seat of the respondent party, or yes, if you are claiming to initiate proceedings, it should be respondent party. Just to be sure that you will not initiate proceedings, pay some initial costs, inquiry costs for legal counsel, and then it would be, and then the domestic law of your respondent would be similar to Polish one. But again, it's not killed from the outset. The opposite is true. It is not killed. It survives unless we have very strict rules for the respondent, as it was Polish rules.
Okay, yeah, so the first task is to check the law of incorporation of the respondent, whether the arbitration clause will still be valid and enforceable despite any insolvency or bankruptcy that might be commenced at the jurisdiction of the respondent, correct?
Exactly, that's correct. That's correct. Because under Polish law, basically Electrim lost its legal personality and arbitration clause became invalid. Because the Pakistan under bankruptcy was not, it was not possible for those parties to enter into arbitration agreements. I just spotted one question. You mean generally cost of Swiss arbitration? Yeah, unfortunately, I would have to run a comparison, but I think it's pretty attractive. But I never did specific comparison, just, with very general amount dispute, like, I don't know, let's say 1 million Swiss francs. I'm not sure I know how it compares necessarily, but I think it should be lower. But maybe you know better.
Yeah. No, I mean, like, it was generally whether it's obvious advantage or disadvantage. I think your answer is no, so it shouldn't be taken into consideration when making the decision.
Cost alone? Or
sorry,
are you saying whether cost alone should be taken as disadvantage? I don't think so.
Okay, yeah, I mean, like,
No,
but
I
for
don't think so.
example, if we're talking about London-based proceedings, everyone knows it's very expensive. So from this perspective, just from practical point, but I think you have already answered the question, so it's not this easy factor when you enter in or not.
I mean, for ICC, because we do have Swiss seated arbitrations under ICC rules. So it would be, you mean if for ICC rules, if it's in Paris, then we should look for administrative costs, not necessarily secretary costs of ICC or Swiss Arbitration Center, but we should also factor in logistical costs and rental equipment and such. But generally, Swiss Arbitration Center recently was reformed. Before we had different arbitration centers, basically different chambers of commerce in Geneva, in Basel, in Zurich, and then they were all unified as yes, as Sky, and then Sky was reborn as Phoenix and became SAC, which markets itself as even more streamlined, more straightforward, and somewhat cheaper. But I think it would be advisable to do the comparison with specific costs, just to be sure.
Yeah. From our experience, so we had a few cases in Sky. So comparing to LCA arbitration, so then of course Sky, as a Swiss arbitration institution, it will be much cheaper comparing to LCA or ICC. But of course, if the amount at stake is high or the dispute is very complicated, so then I think that the cost might be comparable in all these arbitration institutions. But just if you're speaking about some average, not very high value claims, so when we will take Sky as domestic arbitration institution, from my perspective, it will be less expensive comparing to ICC or LCA.
One also practical thing that from my experience, LCA administered arbitrations usually have hourly rates, which is not the case for cases administered by the Swiss Arbitration Center, because the amount for administrative fees would be assessed from the amount of dispute. And that's why it's for emerging practitioners who want to start arbitration career. It was a typical thing that you might get a referral from the Swiss Arbitration Center to be as a sole arbitrator, especially for those cases with lower amount of disputes, which of course, if you would calculate your hourly rate, it would be very low. But this what actually makes Switzerland very attractive for also those smaller cases, and why I used to include, but at that time it was still SIAC, not SAC.
Thank you very much. I think we answered actually the question. Thanks.
Yeah, correct. So Anastasia, one more practical question. So if I'm a counsel for a creditor and the debtor files for bankruptcy in mid-arbitration, what's my first tactical move? Ask for stay of arbitration, lobby the administrator to enter the arbitration proceedings, or raise to an award of arbitration? What would you recommend from the practical point of view?
You counsel for?
Counsel for a creditor.
If you counsel for a creditor, well, definitely I think it would be important to check that, to notify the tribunal of the bankruptcy immediately. And engage with the administrator to seek written confirmation that the state will participate. This would guarantee that once the award is rendered, it is indeed enforceable. And ideally, is also to request a stay, as I said, 30 to 60 days. So would be enough time to assess implications also for the tribunal. It would be just prudent thing to do.
Okay, great. And one more question. For instance, we have a London seat arbitration. We have a Swiss debtor and Swiss bankruptcy proceedings that was initiated against the debtor in Switzerland. And we received a London award of arbitration, for instance, in LCA. How is the London award of arbitration treated in the post-bankruptcy proceedings in Switzerland?
So taxes here would be somewhat different, and it would be important to check New York Convention boxes by administrator, that if satisfied, the award is accepted as a claim in the collocation plan. So it would be enforceable as one of the like in the order of debts. It would be regulated as a debt. It would be placed in this order. But if the award was rendered after bankruptcy and estate was not participating, it might be ignored because Swiss court would treat it differently. That's why it's very important to secure the state's agreement, because in this case you would not have a guarantee that estate agreed to the proceedings. And so basically you have like two-pronged test. If your arbitration started before bankruptcy proceedings, you usually secure. If after bankruptcy proceedings, so basically you sue the insolvent party, you should do all those practical steps to make sure that your award would be enforceable once you have it enforceable. And the difference here, because it's a foreign seated arbitration, it's not Swiss seated arbitration. So the court would not be would treat it as a foreign debt in essence.
Okay, and one more question, if you will allow me. For instance, if our debtor has commenced bankruptcy proceedings, and we are just at the initial stage of arbitration proceedings, what would you recommend the client to continue arbitration proceedings? We are speaking about foreign arbitration, for instance, in London, Or it makes not much sense since the creditor might submit all his claims to the liquidator and just to make a claim to admit the creditor's claim based on the documents available. Is it possible to admit the claim of the creditor without the award of arbitration? Or you would still recommend to proceed with arbitration to prove the amount of claim?
I mean, from Swiss law perspective, it depends from the assets located in Switzerland, because generally, and we all know that it's indisputable, that duly rendered arbitral awards, it's easier to enforce them than enforce decisions of foreign creditors, foreign courts. It's just much easier process. So if you know that you do have assets located in Switzerland, and those assets would not be affected necessarily by other creditors' claims, it might be sensible to continue arbitration. But for that, maybe Yana will also weigh in whether like what would be the practical implications to make sure that the award is eventually enforceable once it's rendered.
Yeah. Thank you, Anastasia, for all your presentation and reply to our question. It was really very practical and very interesting for us to hear. So we wish you a pleasant day, continuing your day and your travel, and we'll stay in touch with you concerning any questions.
I'm sorry for the...
Yeah.
Sorry, it was just good timing. Thank you very much.
Yeah.
Yes, I would have to discontinue, but I would definitely watch the recording once it's ready and posted to hear more about London seated arbitrations. It's also of huge interest, and also about Cyprus and Ukraine. Thank you very much, and thank you for accommodating my early leave. Thank you.
Yeah, thank you, Anastasia. So, and we now will continue with Yaنا Chekavska. Yana will speak and will deal with insolvency in England and any influence it has on arbitration proceedings. And I know that Yana has a very interesting case she was recently engaged in and is still dealing with, and we will be pleased to know your experience of dealing with insolvency in the course of arbitration and any practical tips or recommendations to our audience, how to handle arbitration proceedings in such cases. So the floor is yours.
Thanks. Thank you very much, Irina. Thank you very much for everyone for joining. By way of background, I'm solicitor at London-based boutique litigation law firm Candy. So we deal basically with disputes. So it's arbitration and litigation. In my practice, it happens that I have, I would say, 60% arbitration, 40% litigation. But today I'm going to tell you about, as Irina mentioned, very interesting case. It's interesting because A, it's ongoing for 5 years already. B, it's very multi-jurisdictional one. So for example, our arbitration proceedings are in the LCA 2014 rules at the moment. So by way of background, we have two parties. Unfortunately, I cannot give you names because they're bound by confidentiality and like for obvious reasons, I'm not going to do that. It shouldn't like anyway intervene with our discussion. But by way of background, we have two companies, claimant and defendant, who acted for the claimant, both registered in Cyprus and both members of the same group of companies. So in 2012, defendant took a loan from one of the group companies to fund the internal buyback of shares. So basically, the company gives money to the buyer to buy shares in the group. In the future, it was going to be repaid by way of dividends or something like that. We are not interested in that. So it happened in 2012. In 2020, the loans are not repaid. The claimant started to be like, the loans were assigned for the claimant. So now we can claimant and defendant, members of the same group. The claimant commenced proceedings in the LCA for the total amount of around 13 million. So they were like loans. And defendant at that point of time was in no way involved in bankruptcy proceedings, insolvency, so just like normal company. When everything started, the decision was made by the claimant that in order to get more insights on what is going inside the defendant, in BVI, to commence liquidation proceedings against the defendant's parent company, or based on the completely like unrelated debt. So the claimant and his legal team, including like Candy also, commenced litigation insolvency proceedings against the defendant's parent company and the defendant. And by the decision of the first instance court, the parent company and the defendant were put in liquidation. The defendant and his parent company disputed that, and the case ended up in the Privy Council, which is like a judicial committee, part of the Supreme Court of the United Kingdom, dealing with the claims from overseas territories. So basically, and the appeal of the defendant was rejected. So he is in liquidation, like fully and completely, and there is bounding judgment and decision which cannot be in any way disputed, and so on and so forth. So the idea was great. Defendant should be put in liquidation. The claimant have some kind of visibility and control over that process, because for the first couple of months, claimant even paid the liquidators' costs. And then, out of blue, we received a judgment from the BVI court with no reasons, no arguments, nothing, because the file is sealed, that the conflict liquidator is appointed. So liquidated, strictly speaking, appointed by the court is no longer in place due to some undisclosed conflict inside. I don't know the reasons. No one knows the reasons, although it's been like 5 years ago. So the tool which should be powerful in how to control the defendant by bringing bankruptcy proceedings against it didn't work. It's all like failed. Everything, all the money, everything spent on it. Of course, there are some benefits. We cannot say that it was like in vain, but the main aim wasn't reached. So at the same time, like back to LCA proceedings, LCA proceeding continues, and they were quite lengthy, complex, and expensive. So it's obvious that both companies are in liquidation. They do not have any assets, and defendant, like publicly to the tribunal everywhere, admits it has no assets at all. But someone still keeps like findings and proceedings, and it's like 10,000, I don't know, hundreds of millions. It can be like any amount, we don't know. So in the LCA proceedings, just like last year, maybe like 1 month before the substantial hearing, finally, in front of tribunal, listed for 3 weeks, the defendant withdrew his defense and said, okay, we're no longer want to fight it, despite 5 years of like efforts, money, everything spent. We just withdraw our defense because in parallel, the defendant in the LCA becomes a claimant in the High Court proceedings together with a group of companies involved who move basically its defense in LCA proceedings, which was conspiracy, as a claim in the High Court proceedings. Now they're in a better position. It's High Court. The court has much wider powers as to disclosure, as to management of the cases, as to what it can force the parties to do, and so on and so forth. So, and their claimant, they're in a better position. They can claim their case. So it's for the defendants now, which is our claimant in the LCA, to fight and to rebut all the presumption, everything made. So at the end of the day, what we have LCA proceedings, which are now concluded. The claimant, our client, has a word in its favor. So everything we asked, the loans, the interest, and costs in around like of 3-4 million of pounds in favor of our client. Parallel proceedings in High Court, where we are defendant, BVA liquidation proceedings, which in fact didn't work well. And we now have proceedings in Cyprus. Okay, let's not move to that. So basically, that's where we are at the moment. So defendant is bankrupt, but someone is finding the litigation, all these 3 or 4 sets of proceedings. So now we have a question, and again, it's an ongoing case. No one knows the answer. How to enforce the award? We have like basically 2 limbs. First, to enforce the main debt and to get the assets of the defendant. As far as we are aware, it's only like shares in the holding parent company, the head of the group, and nothing else. And the second limb is how to get our costs paid, because we have cost orders in all of those jurisdictions in favor of our client, which are basically undisputed. Again, you just need to bring the award and receive cost award and get your money. And we know that money are there, but we don't know how to get them. So from these two limbs, how to enforce an award against a bankrupt, insolvent, or liquidation company, depends which jurisdiction terminology you are using. To satisfy the first limb, to enforce against the assets, we are now trying to do that in Cyprus because the company is Cyprus registered through the New York Convention procedure, which is relatively straightforward. I would say a bit time consuming, but still that's an option. But it's not gonna work for the costs, and we want to know how to get our money. And the answer to this may be the existing high court proceedings. In the high court proceedings, the defendants who are claimant, our claimant is a defendant in those proceedings, have recently applied for disclosure orders against all of the claimants, including defendant in the LCA proceedings. Because everyone knows that it's funded by someone, and there are a lot of cost order outstanding to each of the defendant. So how to get those paid? So it's now live. The court, the judge, the hearing would be held next month. So all the parties is trying to do is to get the identity of the funder, who is funding, with the view to bring claims against that party. The problem here is that, for example, our client, the claimant who is defendant, have very small amount due to him now after the security of cost funds were used is 50, 60, 70,000 pounds. For English court, it's not a very persuasive amount to disclose confidentiality, to disclose and to intervene with the stuff which is basically not relevant. And it's highly unlikely that the identity of the funder would be disclosed in these proceedings for us, for example, for our client. So we know that someone is funding, we don't know how to get the money. There is one option, very slim one, as based on the facts, as we're advised by our counsel, that in order to give the English court wider powers as to our arbitral LCA award, we can recognize the award in England. So under Section 66 of the Arbitration Act, you can do that. You don't need to prove anything, no need to show assets in jurisdiction or connection to the jurisdiction. It's just very low threshold. So after it happens, in theory, the English court would have the same powers in relation to this case as it has in relation to all domestic English law cases. So once we have these, we can apply for the disclosure order, to ask the court to make a disclosure order against the defendant. So defendant would need to disclose all these assets. Defendant, in theory, and it probably would happen, should disclose no assets, because it's publicly admitted it has no one. And then it's for us, for the claimant, to show that either the proceedings are funded from undisclosed assets, or B, there is someone, it's usually called third-party funder, funding these proceedings. So the court may order that party undisclosed, secret. Usually they have a lot of reasons why they're low profile and they're not mentioned anywhere, to disclose the finding arrangements and the identity of those who is finding the arbitration. And only after that, in theory, we can sue the third party in order to get our money. It's a lot of ifs, and buts, because of course the opposing party would be very strongly resisting it, and because the main case in the High Court is based on conspiracy, which involves a lot of secrecy and all these hidden motives. someone is scared for their life, for their business, and so on and so forth. So it's highly unlikely that the High Court would take responsibility and will go as far as ordering like all these kinds of disclosure orders against the party. So, well, fighting this at the moment, there is no answer to all these questions. And like a lot of legal teams from various jurisdictions are trying to get the answer and to get the situation, how to enforce two awards, basically cost award and substantial award against the bankrupt party. Because from procedural perspective, there are no obstacles. You can do it. The liquidators like will take care of all and need to take care of all. But from practical point, in theory, they don't have any money, but we know that they have, but we just cannot reach them for now. So that's where we're at the moment.
Yana, thank you for this interesting case. So this demonstrates a very practical tool that you basically used in solvency proceedings as an additional measure to take control over your defendant while you were in the course of arbitration proceedings. So it's really very interesting. And let me clarify. So your defendant, as far as I understand, is registered in Cyprus.
Yes.
Yeah. And did you commence insolvency proceedings as well in Cyprus, or insolvency was commenced only in BVI against a parent company and its subsidiary, but not the defendant, or the defendant was as well among the companies in insolvency?
No, your first statement was correct. We commenced only in BVI against the parent company, but because it's 100% owned subsidiary, the liquidators were appointed also to the board, like as the directors of our defendant. We were not interested in the insolvency itself because there is no assets. So we know that. We were more interested in like this shift of control from the directors of the company to the liquidators, who, as opposed to the directors, would act in the interest of the company.
Yeah, okay. And insolvency is going on, it takes place only, or liquidator is based only in BVI, but there is no insolvency in Cyprus.
There is no insolvency in Cyprus, but because our client and a couple of other like subsidiaries of the company in liquidation were all 100% owned subsidiaries, so they basically were the assets of the holding company. They all are under control in like after the management of the same liquidator.
Okay. So in order to just to give additional practical tips to our audience, do we understand correctly that in England seated arbitration, like in your case in LCA proceedings, the bankruptcy that was commenced against defendant based outside England jurisdiction, or even against English-based companies, would not prevent or circumvent continuation of arbitration proceedings?
No, and the first reason for that is arbitration clause, because parties validly agreed that the laws of England and Wales, or any other laws apart from the procedural one regulating the seat of arbitration, would not be applicable. It was their choice, and they voluntarily entered into that agreement. Is the first point. And the second one, so once you have it doesn't influence the arbitration in any way. Once you have the award and you need to enforce it, then it can be an issue in terms of enforcement. You need to go, as Anastasia mentioned, into the list of creditors, and then the law of the company where the insolvency or bankruptcy took place would come in action. But from English law perspective, no, because arbitration and let's say rules and arbitration itself, it's a separate world which is somehow protected from all that outside influence, and that's usually the choice of the parties to get that protection and separation.
Yeah. It's really very helpful because it distinguish drastically, for instance, from Ukrainian jurisdiction, since here everything is much more complicated.
English
So-
law, like not arbitration, normal English law, just to touch like for a very tiny bit, I think it's very similar to Ukraine. So once a company is in liquidation, administration, or voluntary administration, and so on and so forth, you cannot commence proceedings. There is a period called moratorium during which you cannot do anything. You can bring the claim either by the permission of having the permission from the court or from the administrators or liquidators who, for various reasons, may want to leave that moratorium for you to bring the claim. Otherwise, like, no.
Yeah,
I think the interesting point here arises if you started your arbitration proceedings and enforcement before the company entered liquidation. I'm in Ukrainian courts for 5 years now, unfortunately, with 2 claims against a bank that was a perfectly capable and bank functioning well, and that has entered liquidation during the time that we are trying to pursue our claims. And now the court says we have no jurisdiction, go to the liquidation commission. And we are saying, hey, we started this proceedings 5 years ago when the bank was still there. So first we need to get a judgment in order to go to the liquidation commission afterwards. And our Ukrainian courts up to the Supreme Court is saying, no, you go to liquidation commission, which is completely, we argued the same argument in Kazakhstan. Civil procedure codes are similar and civil codes and bankruptcy rules are pretty similar. And we won with Supreme Court in Kazakhstan, which says, okay, yeah, court has jurisdiction. So we got the judgment and then we entered the register of creditors, which is currently like the procedures ongoing. In Ukraine, the completely opposite result. The Supreme Court is adamant, saying, no, you guys go to liquidation commission. Yeah, we have nothing to go to liquidation commission with because we don't have a proven debt. We don't have a judgment, right? So it's a very difficult situation, I think, when the liquidation starts underway. When the proceedings are ongoing, then the company goes bankrupt, and then what do you do? I think it depends on the national law, and I would be super interested to hear, Victor, because my Ukrainian experience is really, really painful in that regard. But I think
because no one wants to take responsibility. The courts at the moment, they don't want to take responsibility over this proceeding. They just like send you basically to the liquidation committee, and
the liquidation committee sends you back to the court because they say,
yes,
you started proceedings 5 years ago. We were not yet there. Like, what do you want from us? Come back with a judgment. So it's a very complex and painful matter.
Yeah,
But
and Natalia, in your case, do you understand correctly that the claim on the merits is considered by the court?
by the court, yeah, the court of we started with the first instance court. Yeah.
Yes, because we have like a quite similar factual background as your case, but we are fighting against the bank in Ukraine that is in the course of liquidation. But contrary to your case, our case on the merits has been considered by the arbitration. It was ICC arbitration seated in Hong Kong. And Ukrainian court said, so no problem, your arbitration clause is valid, so go receive the award of arbitration. And we received the award of arbitration against the bank that is in the course of liquidation proceedings in Ukraine. And we commenced recognition and enforcement proceedings in Ukraine against this bank. And just last week, we received a Ukrainian court order recognizing the award, ICC award of arbitration against the bank in liquidation. But there is a very clear distinction in Ukraine between liquidation and bankruptcy. So considering the fact that our bank is in liquidation, that means that arbitration agreement is still enforceable, valid, and it can be performed. However, if the bank would be in bankruptcy proceedings, then the situation would be opposite. And I think that your problem lies in the fact that you do not have arbitration clause, most probably. And that's why it brings a lot of complication, because you need to continue some proceedings, court proceedings abroad, and at the same time you have liquidation procedure in Ukraine that is very tough, and they are saying, we know nothing, so we don't accept your claim, or we accept in a certain amount and we don't admit more.
Yeah, but it's just an example how different laws treat these issues in a very radically different ways, even comparing here the law of Ukraine and the law of Kazakhstan. But coming, suppose, to the law of Cyprus, and discussing, well, first of all, I'm very grateful and pleased to have Agis here on this panel and to discuss this issue, because he's both qualified in England and in Cyprus, and Cyprus law is very much common law influenced. Agis serves as an arbitrator in many disputes, including disputes regarding bankruptcy and liquidation proceedings. So proceedings related matters. So I think it would be very, very interesting to hear from Agis about some Cypriot law complexities as regards the insolvency impact on arbitration matters and arbitration proceedings. Just to start our discussion with Agis, Cyprus is very much common law influenced jurisdiction, and common law principles also, as far as I know, they impact insolvency. But as regards the private law and how it interacts with insolvency issues in some ways, for example, with regards to voidable transactions, preferences, other matters that are governed by the company's law regulations in Cyprus. Do you see, like, what are the examples of how insolvency related issues of private international law can arise in the course of arbitration?
Thank you, Natalia, and thank you very much for inviting me to join this panel, this very interesting conversation. Let me start by saying that Cyprus generally treats the matter of insolvency as an issue of arbitrability, but that is probably an oversimplification. It's probably the result of statistics, in the sense that most of the cases that deal with the matter are, for one reason or another, relevant to the issue of arbitrability. But I will also give a few examples to show how complications may arise if we do not look at the more general provisions of Cyprus law on the issue, which could cause some unpredictable problems sometimes. So the general position in Cyprus law is that if you have an arbitration clause and there is a dispute and you wish to go to arbitration, or you have already commenced an arbitration, you need to apply for what we call a carve-out order. So you need to apply to the insolvency court and ask for a court order allowing proceedings to continue. And this is the same whether the proceedings are court proceedings or arbitral proceedings. Just to give you an example of the treatment by the Cyprus courts, I mean, I think a very good example is a case called LMI from 2018. In this case, we've had arbitration proceedings that had already commenced, and the respondent went into liquidation. So there was a general meeting of creditors, and the claimant in the arbitration was invited to attend. So the claimant appeared on the set date and time at the appropriate place, and then was refused entry. He was basically kicked out of the room. So he went back to the court and applied to have the decision of that general meeting invalidated because he was refused participation in the general meeting. And I stress the point again that he was invited to attend that meeting. And the court held, in that case, the Supreme Court of Cyprus held that it was correct that he was not allowed into the room because he was not a debtor. What he had to do was, in order to be considered a debtor, was to apply for carving out, proceed with the arbitration, obtain an award, and have it recognized in the Cyprus courts. So this very restrictive definition of debtor that is applied throughout Cyprus case law probably lowers very considerably the threshold for obtaining a carve-out order. So it makes it easier to obtain a carve-out order. But at the same time, this case shows how important it is to obtain it, because if you do not, then you will not be able to proceed with the arbitration, but you will not be able to proceed in the bankruptcy or liquidation proceedings either. So you will be left with no other option. Now, two examples of our statutory provisions just to show the complications that may arise. In Cyprus, when we have a winding up order, the relevant date for commencement of the liquidation is not the date of the order. It is generally the date of the petition. So you may have the situation where a petition is filed today, arbitration proceedings have already commenced or may have commenced after you have filed the petition. And a year later, a court order is issued for the winding up of the company. The deemed date for the commencement of the winding up is the date of the petition, which is 1 year before. So the issue of arbitrability may arise retrospectively. If meanwhile you have obtained an arbitration award and you have not applied for a carving out, then that could be a very serious problem and result in serious implications in the enforcement of the award. So that is one issue to look out for, because it also has to do with the strategy that upon which a party will proceed in its case. The other issue, which is relevant to capacity and is very important, it is fraudulent preference, which means that if, for example, you have the giving away of an asset as a gift or at an undervalue to a related person, if that was done 6 months, up to 6 months before the filing of the petition to wind up the company, or after that date, then that would be, and you show that there is an undervalue, that is deemed to be a fraudulent preference. And that means that the particular transaction is voidable. So this will have to do with the capacity, of course, of the parties, and it may also lead to retrospective problems if meanwhile you have obtained an arbitration award, or if you have taken significant steps in the arbitration proceedings. So just to sum it up, I mean, as I said, it is generally an issue of arbitrability, and generally what you need to do is to apply for the carving out order, but that's an oversimplification. You need to be a bit more careful about the various contingencies that may arise in these situations.
And in terms of the timing, Aegis, if we are speaking about a party, for example, a claimant, a potential claimant, an applicant that is thinking about bringing in an arbitration proceedings, but there's been a petition filed, say, some months ago or a year ago, does it impact on that party's standing at all, just the fact that the petition was filed and is pending?
Well, as I said, because the application for carving out is made if and when a winding up order is issued, it is quite problematic if you are in the situation where you're in between. If you are between the time that the petition was filed, but before the issuing of a winding up order, then you are left in an uncertain area. So you have to be rather proactive there are, of course, many options which will depend on the circumstances of the case. I mean, one possible way out is to ask for a stay of the arbitration proceedings until the matter is determined by the winding up court. Another possibility is to proceed with the arbitration and then take the risk, of course, of applying retrospectively for a carving out, which is quite risky, I mean, in my mind, but it may be a possible option in some cases. So there are many possibilities, and this can be made even more difficult if the winding up proceedings are abusively brought, because it's not just creditors that can bring these proceedings, it can be a voluntary winding up. Sometimes it is the respondent who initiates or causes the initiation of these proceedings just to torpedo the arbitration proceedings. So it is, I don't think, at least, I don't think I'm in a position to give a general strategy that could apply to any possible case. There are many complications and factors to be taken into account when deciding how to respond to something like that.
And aside from the timing of when insolvency was initiated, another issue is probably worth considering in terms of strategies, the applicable law and the complexity of the law that could apply in the context of insolvency. So what would be the position in Cyprus, and have you encountered any interesting case law examples in that regard?
Well, first of all, okay, the tribunal will generally apply its own conflict rules to determine what the applicable law is on this matter. But again, I think that especially if you're acting for the claimant, you need to look at the more general position and try to also look at what the position of other possibly relevant forums would be, especially the places of potential enforcement, because they may apply different rules and they may reach to very different conclusions in respect of the effects of the liquidation. So again, that's quite a challenge usually to be able to foretell what may happen and try to prevent it by getting the right advice from all the relevant jurisdictions at the right time. Anyway, in Cyprus, we do have the model law on arbitration, which means that incapacity is a reason to set aside or refuse enforcement of the award. So the matter of capacity is relevant. And of course, we need to look what the effect to capacity is when a party goes into liquidation. We also, as a member of the EU, we apply the European recast insolvency regulation, which basically provides that the law applicable to the insolvency proceedings and their effect is that of the place where the proceedings are opened. And generally, proceedings are opened at the place of the debtor's main interests. In the cases of common law jurisdictions, which follow the registered office approach, this is usually more simple to determine because registered office is presumed to be the place of main interest. So if you just look at where the company is, what maintains its registered office, it's quite easy to tell what place is probably the right place to bring winding up proceedings. This may not be the case in seat theory jurisdictions where the matter is very different and more complicated. But in any case, once proceedings are brought and the insolvency court assumes jurisdiction, then it is the law of that court that should be applied to determine the effect of the insolvency. And this also seems to be the position that at least the working group number 5 of UNCITRAL seems to be moving to the same direction, which is to apply the lex fori concursus, or the law of the place where the initiation of insolvency proceedings took place. Now, again, this is, of course, doesn't solve all the possible complications that may arise. I mean, an extreme example I can think, but I cannot easily find the answer, is what happens if you have a party that's a joint venture and it comprises two companies from different member states. They both go into liquidation, but the applicable laws provide for different effects on the arbitration proceedings. What do? Do you proceed only against one of the two parties to the joint venture? So there are complications which have not been resolved, and I understand that these sort of issues are currently being discussed by Ancitral. Hopefully they will come up with something more sophisticated than a simple application of the Lex Loci Concursus, but we are still to find out about that. If I have time, maybe I could refer you to a case that I was involved in, which was quite difficult to reach a decision on this issue. It was case of, there's a very famous case about JNP against FBME Bank. And that is an investment case. But in parallel to that, there was a construction case with a Cyprus seat. And I was one of the arbitrators in this case. It was decided a few years ago, not too long ago. Anyway, what happened here was that there was an application to liquidate the Tanzanian branch in Cyprus, which did not result to winding up at the time. And in parallel, there was a statutory liquidation of the Tanzanian bank in Tanzania. So it was a case where we looked into the Viventi Electrim jurisprudence to decide on what it is that we had to do. And we decided that given that the liquidation in Tanzania had commenced after the arbitration proceedings began, that this was an issue of arbitrability, and we applied the lex arbitri, which was the Cyprus law. Under that law, there was no obligation to suspend the proceedings. However, we did decide to proceed with the arbitration, but however, we also took into account Tanzanian law. And the reason for that was because we were concerned that if proceeding with the arbitration in Cyprus, even though this did not violate the Cyprus arbitrability rules, we were concerned that if we violated a very significant rule of Tanzanian law, this could be raised under the public policy ground to resist enforcement of the award. So we looked at the Tanzanian law, and it was quite peculiar and difficult to find out what was the case there, because this was not an ordinary winding up where following the application of a creditor. This was a case where there was a statutory winding up, and there was a specific law dealing with the matter, which did refer to the Tanzanian companies law, but adopted the liquidation provisions only to a certain extent, and it did not adopt any provision that related to the effect of the liquidation to pending proceedings. So on that ground, we decided that this was a case that even if the lex loci concursus applied, or should have been taken into account for reasons of public policy, still there was no violation of a mandatory rule of law of Tanzania, and therefore we considered ourselves free to proceed with the case. So it was a very peculiar case, one of the most difficult I had to encounter on this issue, at least. And we were very lucky that the case was eventually settled, and our decision was not tested by the courts. But I'm quite confident that it was right.
Yeah, thank you, Agis. I was about to ask about the impact of insolvency issues on public policy and the interaction between the two, and to what extent the insolvency issues can be excelled, as Anastasia pointed out earlier, based on Swiss law, to public policy matter that would, of course, impact enforceability of the eventual award. Are there any other examples of how insolvency issues can be treated as a matter of public policy in Cyprus?
Well, generally, if the applicable law is what is foreign to the Cyprus Forum, and that foreign law provides that you cannot proceed with the case, be that in arbitration or elsewhere, unless you obtain a permission or by the relevant court, then that could be raised as a matter of public policy. And there were first instance cases where this was raised, but we don't have any solid Supreme Court case law deciding the matter. But I'm quite confident that if there is a violation of that matter and the applicable law, the law of the Insolvency Court, is strict in the sense that in order to protect other creditors or for various other reasons, require certain procedural steps to be taken before arbitral proceedings can continue, and these are ignored, then this could raise a serious issue with the enforcement of the award. So I think that one ought to be very careful with that.
Thank you. I think we have one question from the audience, from Dimitru Lungu, and I will read the question. It doesn't specifically refer to Cyprus, but it's a practical one. Question for everyone: are there any possibility of a party to access third-party funding while insolvency case is in an ongoing trial? In your experience, did you had any third-party funders involved in the proceeding while one of the parties was insolvent or undergoing bankruptcy proceedings?
Well, I had a case where the claimant, I acted for the claimant, and the claimant was in liquidation. And actually, it was the liquidators who obtained funding for the case, because it was a very significant energy dispute for a large amount of money. And it was not possible for the company or the liquidators to fund the case otherwise. And they did secure sufficient funding, and the case proceeded. And actually, the claimant did obtain a very favorable award in the end. So yeah, I don't really see the problem. I see that the insolvency of a party, especially if that party is the respondent, will be taken into account by the funder, amongst other factors, when deciding whether to fund or not. But I don't see it as something which is leads necessarily to a yes or no position by a funder. It's just one more relevant factor.
Thank you very much for your comments on this complex issues and your observations on the Cypriot practices regards insolvency. Irina, unless there are any other questions, I think we can proceed with from Cyprus to Ukraine.
Yes, thank you. So, and we'll now continue with Ukrainian jurisdictions that might be quite distinguished from all other previous jurisdictions. And I give opportunity to make the presentation to Victor, our associate at AGA Partners. So, Victor, please, you are invited. As far as I know, you have a short presentation, so you can share your screen.
Yes, many thanks for inviting, and good evening to all. So now I will try to share my presentation and start my speech. Okay.
So, Victor, we don't see it. Can you try it again?
You don't see, yes?
Yes.
Okay, I will try. Can you see it now?
No, unfortunately, no. Maybe you should try one more time or in the other way.
Okay, so you still cannot see the presentation.
No, or if you can click just to check. Yes, now we see it.
Okay, great. Maybe there is some time lag. Okay, so I will start with general regulatory framework governing the intersection between international arbitration and bankruptcy proceedings in Ukraine. And after that, I will move to outlining some peculiarities of enforcement against state-owned companies and companies from particular industries that exist in Ukraine due to wartime restrictions and due to significant influence of the state over Ukrainian economy. So to start with, commercial courts have an exclusive jurisdiction in Ukraine over claims against insolvent companies. The commercial court of the first instance located at the place of registration of a debtor consider all such claims, and all such claims must be filed to this court even if the corresponding dispute resolution clauses provide for international arbitration or other dispute resolution mechanisms. Additionally, to these regulations imposed by the Bankruptcy Code of Ukraine, there is provision in the Code of Commercial Procedure providing for non-arbitrability of any disputes arising from monetary claims against insolvent debtors. Based on this, there are grounds for Ukrainian court to refuse recognition and enforcement of arbitral awards and to set aside arbitral awards rendered in Ukraine-seated arbitrations based on non-arbitrability ground, which is enshrined in the New York Convention and in Ukrainian law on international arbitration.
Victor, I'm sorry, can you click the presentation or to share it as animation, because we don't see the second slide.
Okay, so do you see the first slide?
Yes.
Called arbitrability and enforcement.
No, we see just the first arbitration and bankruptcy in Ukraine. We don't see the second, arbitrability and enforcement.
Okay, so do you see the second slide?
No.
Okay, then maybe I will continue without presentation to simplify things. Sorry for this technical inconvenience. Okay, so despite the fact that recognition and enforcement of arbitral awards rendered in violation of this non-arbitrability clause, there are provisions and court practice allowing to enforce arbitral awards which were rendered in arbitrations which have been commenced before the arbitral proceeding. So if the claimant commences an arbitration and only after that the debtor files for its own liquidation or another creditor commences the liquidation proceedings, then the claimant can successfully recognize and arbitral award in Ukraine. Also, there is some contradictory court practice on recognition of arbitral awards monetary disputes. For example, there was a case where a major Ukrainian bank managed to obtain a court order referring the parties, one of which was in the bankruptcy proceedings, to the ICC arbitration under the bank guarantee agreement to consider the contract invalidation claim. So unlike monetary claims, which are considered exclusively in the court which manage the bankruptcy proceedings, non-monetary claims may be considered in arbitration. Particular risks related with arbitration commenced after bankruptcy proceedings in Ukraine depends on the seat of arbitration, because while foreign-seated arbitral tribunals tend to disregard provisions of national law of one of the parties and be guided only by the law of the seat, which do not prohibit such arbitral proceedings. Arbitral tribunals deciding disputes in case where the seat is, for example, in Kyiv, Ukraine, may rule on absence of their jurisdiction due to the non-arbitrability. And also there is a risk of award being set aside by Ukrainian court due to non-arbitrability. In any case, for both scenarios, for either awards made by foreign-seated tribunals or Ukrainian-seated tribunals, there is a risk that such award will not be recognized in Ukraine. So moving to peculiarities of bankruptcy proceedings and what the creditor should do to safeguard its rights, it should be said that from the day one of the bankruptcy proceedings, a moratorium on satisfaction of creditors' claims is imposed, and this moratorium precludes seizure of any assets of the debtor and any interim measures against such debtor's assets, such as arrest of his shares, his cargo, his vessel, let's say, and other assets. So Ukrainian law prohibits bailiffs, both private bailiffs and state enforcement agency, from making any enforcements against the debtor, even based on the writ of execution issued by Ukrainian court, which have recognized and allowed enforcement of the arbitral award. So when the bankruptcy proceedings have commenced, the creditor have no other option than to apply the claim and evidence supporting this claim. Formally, there is no res judicata effect of arbitral awards and of judgments of Ukrainian courts allowing the enforcement of such arbitral awards. But in practice, there may be some benefits of having an arbitral award, or in the best case scenario, the writ of execution issued by Ukrainian court, which authorized the enforcement. Because many judges may treat such claims more favorably as more substantiated, but still there is no direct legal provisions for this, and any creditor should file all evidence it has, not only arbitral award and court order, but also the underlying contract and evidence that have been submitted in arbitration. Okay, so now we will move on to peculiarities of enforcement against state-owned companies and companies from particular economic. It should be said that in Ukraine there are a lot of such restrictions. There are some provisions completely prohibiting enforcement and some provisions limiting the enforcement against such companies. The problem is that there is like no consolidated law or some provisions in particular law on that, and there are dozens of such provisions in various laws and other regulations. Among such restrictions are the prohibition of enforcement of arbitral awards. I mean, not through courts, but by bailiffs when the creditor have already obtained the court order authorizing the enforcement. Against companies from the defense industry, not only from like Ukroboronpro, the largest one, but other companies as well. There are also restrictions on enforcement against coal mining companies, against Ukrainian state-owned railway operator, and against operators of critical infrastructures in which the state has a significant share. This predominantly energy companies like ports and operators of transport infrastructure. Also, there are some territorial restrictions, so no enforcement can be commenced against assets located on the occupied territories or territories of active combat, as well as against companies which are registered in such territories. And there is a real problem with that because like we had cases when we tried to commence the enforcement as soon as possible because the company was registered in Sumy region or Kharkiv region, let's say, where there is like 30 kilometers to front to Russian army and or 50 kilometers, and there is a risk that tomorrow these territories will be included in the list of territories on which the enforcement is prohibited. This not only complicates enforcement in general, but also have a major impact on bankruptcy-related proceedings. For example, state-owned companies often raise this defense in proceedings concerning the enforcement of arbitral awards. They argue, for example, state-owned company that no award can be enforced against it. But the court practice clarified that this concerns only bailiffs, not enforcement of arbitral awards through courts. Another defense often employed by state-owned companies is that enforcement of the arbitral award is contrary to the public policy because there is a significant risk that it will result in bankruptcy. So if the award is enforced, the respondent, the debtor, goes bankrupt, and this may cause significant problems for Ukrainian government and our society. There were two interesting cases with different outcomes which I have analyzed for this webinar. The first case is a dispute between the company called Lionel Air and Ukrainian weapon vendor state-owned company Ukrospetsexport. Lionel Air obtained an arbitral award for around $4 million and tried to enforce it in Ukrainian courts. And Ukraine Ukrospetsexport argued that this award will result in its bankruptcy. And based on this, asked the court to refuse the recognition and enforcement on a public policy grounds because the debtor is one of the largest defense procurement agencies, procures arms, ammunition, and military equipment for Ukrainian army, which is essential in the course of a full-scale war. But the court dismissed this argument, although it was not directly stated, but I think it would be because of the disproportionately small amount of claim comparing with the size of the respondent company and its assets. But in other cases which I have analyzed, the court could admit such defense when the claim sum is such that it may cause the real bankruptcy of the company, not a mere charge. And the court also emphasized that Ukrospetsexport is a separate legal entity with its own bank accounts, its own assets, its own managing bodies, and its statutory goal is to obtain profit. So it's conduct commercial activity, and it cannot raise public policy as a defense in this context. In addition to that, Ukrspets export argued that enforcement of awards is prohibited against the military and defense companies during the wartime, but the court clarified that it is not prohibited to apply to Ukrainian court and obtain the court order allowing the recognition and enforcement of the award. It is prohibited only to make enforcement action, meaning that the claimant can obtain the writs of execution, but cannot seize or arrest assets of the respondents. So based on this, the court dismissed the defense and allowed the enforcement. Contrary to the approach taken in this case, there was another interesting case, Oscam against Odessa port plant. It's an older case concerning enforcement of a major award issued under the rules of Swiss Chamber of Commerce, under which the claimant was awarded with more than 200 US millions, so a very major sum. And the defendant, a major Ukrainian chemical plant, which was owned predominantly by the state, argued that the recognition and enforcement of the award should be dismissed due to the risk of bankruptcy of this company, which could result in harm to the national security, because this company was a major natural gas trader, a major producer of chemicals, and major trader in fertilizers, which are essential for our economy. Another reason was that the bankruptcy of this company could result in harm to environment, because it's a plant which works with explosive matters and other dangerous things. And the court, quite surprisingly, maybe admitted this defense and refused the recognition and enforcement of this award based on the public policy due to the risk of bankruptcy. The court emphasized that the value of award, the awarded sum, was around 1/3 of all assets of the debtor. So the risk of bankruptcy was very real. And another ground was that it was prohibited to enforce arbitral awards against companies which were listed for privatization. At that time, the Ukrainian government tried to auction Odessa port plant, selling it to some major institutional investor. So the court stated that it would be contrary to interests of Ukraine to risk the bankruptcy of this enterprise, which could be privatized, bringing many millions or even billions of dollars into Ukrainian budget and attracting significant investments in our heavy industry and chemicals production. So to summarize this, I would say that it is quite difficult to enforce awards and enforce them efficiently to collect money when the debtor is a state-owned company, especially in cases where there is a threat of bankruptcy or an actual bankruptcy, but still it's possible. And in recent years, Ukrainian courts, they have adopted more proper arbitral approach, and the share of some strange judgments that could be motivated by a lack of understanding of arbitration or by some politics, like judges trying to favor the state, the share of such judgments is declining, so we hope that it would be possible to enforce such awards, and that our legislation concerning this and concerning bankruptcies will move into a direction more favorable to creditors without such excessive restrictions. So I think that's all. I would be happy to answer questions or to hear your comments and discussion.
Thank you, Victor. It was especially interesting to hear concerning the enforcement against Ukrainian state-owned companies and the possible arguments of bankruptcy as a defense against the enforcement proceedings that in some cases was really successful. So I have one question to you. So let's imagine that if we have a London-seated award of arbitration against a debtor that is in the course of bankruptcy in Ukraine. What will be the practical effect of such award of arbitration from the practical point of view? Whether we would be able to enforce it in Ukraine or just to use as a confirmation of the amount of creditors' claim within the bankruptcy proceedings?
Yes, when the bankruptcy proceedings have already been commenced, an arbitral award, whether issued by Ukrainian International Arbitration Court at Ukrainian Chamber of Commerce and Industry or some foreign seated tribunal like LCA, it could serve only as evidence supporting the claim, but not an independent, self-standing ground for collecting money. So the creditors having arbitral awards, even those which have been recognized by Ukrainian courts, they, from a purely legal standpoint, stand in the same position as those who have no awards, who have just contract and some proof that the debtor have not paid money or damages or whatever.
Yeah, thank you. Thank you. So, Natalia, do you have any questions? Just
Thank you. All good on my side.
yeah, thank you. So I want to thank to all our participants and the audience for our webinar, and to thank you for great presentations, and Natalia for assisting me in moderating our webinar. So we hope that it was practical and useful for you to get information from different jurisdictions. And we hope to see you during our other webinars. So our webinar was recorded, so it will be available for repeated reviews. So I think that Ukrainian Bar Association will send a link with a recorded webinar, so you can follow up if you wish to recall all our discussion. Thank you, Victor. Thank you, Agis. And I wish everyone a nice evening, and hope to have other discussion during the next events within Ukrainian Bar Association.
Thank you very much.
Thank you very much. Do not hesitate to contact us if any questions. Have a nice evening all.
Thank you.
Yes.
Thank you.
Goodbye.
Goodbye.